Thank you all for coming on a beautiful day. I remember when I first moved to Minnesota, I was talking to one of my neighbors a number of years ago, and the weatherman had said, hey, get out and enjoy the nice day. It might be one of the last nice days we see for a while. And he said, Minnesota, you don't know if that means 2 weeks or 6 or 7 months. So hopefully everybody's enjoying the weather here. For those of you that don't know me, I'm Nate Zeller. I'm the Chief Investment Strategist here at Secured Retirement. I work real closely with Joe Lucy, of course. I'm more on the investment side. And today we're really honored to do something a little bit different, where we're not talking so much about investments. This is, secured retirement, we really pay attention to, income planning and retiring, those types of things, but we also want to take a larger holistic approach and look at other aspects, of things that matter financially, just not only financially, but also, with well-being. And so that's why we're honored to have Lauren Fink with us today. Lauren is an elder care attorney with the firm, correct me if I butcher this, and I apologize, Mazur, Amundsen, and Boggio?
Yep, perfect.
Nailed it. It's a great firm, very well respected, right down the road here too. I know some of you are probably familiar with her, so we're glad that she's with us. I did notice online too that she was named to the Super Lawyers Rising Stars list, so congratulations on that. Certainly worthy of some applause. But I'm going to let you take it from here, Lauren, and tell us all you have. So thank you.
I'm going to make quicker. Do you want to do your slide?
Oh, yes. Thank you. A couple of slides. We are doing our seminar this Thursday evening with Ed Slott, America's IRA expert. I'm not going to spend a lot of time on this because, quite frankly, we're full. We're pretty close to it. So if you're planning on coming, that's great. We look forward to seeing you there. If any of you have an interest, let us know. I'm sure we can slide you in, but there's really not many slots left. And then the next slide here, of course, thank you, the attorney. On this, our disclaimers. Any information is subject to change without notice. Your individual situation. I'm going to butcher this here. The information is for general information only. They may not apply to your individual situation. We here at Secured Retirement do not give tax and legal advice, and that's why we have people like Lauren here that we work with real closely that can actually give legal advice. So thank you.
Thank you. All right, well, welcome everybody today. Thanks for coming, and thank you for having me, team at Secured Retirement. My name is Lauren Fink. I'm an attorney at the law firm of Mazur, Amundsen, and Boggio. We're over in Richfield in the Woodlake Center, just off of 66 in Lindale. And I will be talking to you today about what to do when a family member has a health crisis. So when we're talking about a health crisis, I'm an elder law attorney. So the aim of things that I talk about as an elder law attorney are typically long-term care planning is what I'm talking about when I'm talking about a health crisis. So what happens if you or a loved one has a health event that now you are going to need care for a very long time or perhaps the rest of your life? What are the things that we need to do? And what can your family members do in order to help you get your affairs in order? So our objectives today are to learn what the immediate actions are to take when a family member has a health event. What do we do right away? Identify the types of long-term care services that are available. So there's a lot of different things that can be ways that we receive long-term care. What are those and what are the pros and cons of each of those? And then we're going to talk about strategies for paying for long-term care, and then briefly touch on the availability of government benefit programs. So one of the things that you may be asking yourself is, what is elder law? I'm an elder law attorney. And elder law is a practice that focuses on issues that are affecting seniors. So I like to sort of think of elder law as, if you're an elder law attorney, you have to be a Jack or Jill of all trades, because there's a lot of different things that can happen to people that are 55 and older. And there are different areas that they're affected in, and I got to know a little bit about all of them. So estate planning is one of those things. powers of attorney, healthcare directives, wills, trusts, all of those, figuring out where to get your assets after you're gone, and planning for any period that you might be incapacitated during your life. Long-term care planning, how do we pay for long-term care, and how do we protect your assets to make sure that you don't lose everything in the event that you have a long-term care event and now you need those long-term care services. Accessing those medical assistance benefits, veterans benefits, if you have long-term care insurance, figuring out how to work with that insurance provider. Special needs planning is a part of the practice too. If you've got a relative or with a disability, is their planning incorporated into your plan to make sure that they're going to be protected? Guardianships and conservatorships. I think that we're all a little bit more familiar now with what a guardianship or a conservatorship is since Britney Spears has been in the news a lot lately. So dealing with those court-appointed alternate decision makers. Estate and trust administrations after you're gone, getting your assets where they need to go to your heirs. And then litigation is a part of elder law too. So when we're looking at the topic that we're talking about today, what do we do if we have a family member that has a health event? The first thing that should be looked at would be, where are the estate planning documents? And the reason for that is that we can generally expect that if someone's had a health event, they might be in a hospital, they might be unconscious, or they might be physically incapacitated. They're not able to run around and do all of the things that they're ordinarily able to do. So why the estate planning documents are important is because those are the documents that say who can step in and start to make decisions on behalf of that family member who's had a health event. And the two most important documents immediately would be a power of attorney and a healthcare directive. So a power of attorney is a document that says, who is someone who can have access to my bank accounts, who can make financial decisions on my behalf, who can step into my shoes and be an alternate decision maker. A healthcare directive is a document that says, if I'm not able to make my healthcare decisions, who's going to be able to make those healthcare decisions for me? So when we're trying to help that family member, if we need to figure out what is the care that they're being provided, what is the condition that they're in, how much money do they have, where are their bank accounts, we're not going to be able to get any of that information unless they've already executed a power of attorney and a healthcare directive. Think about it. If we could call a bank and say, hey, where is the bank account in my mom's name? How much is in there? We don't generally want that information to be disclosed unless we've given permission to do so. So the power of attorney and the healthcare direct give that permission. The other thing to look at in who are the agents in your family member's plan would be maybe they've executed a trust. A trust is another estate planning tool. And if assets are titled into a trust, the person who has power of attorney doesn't have access to those, because the person within that trust document has appointed a successor trustee. So there'll be a trustee who has access and control to the assets inside the trust, and a successor trustee, who's someone that might step in the event that the person who was originally acting can't act. So again, it's just reviewing the documents and seeing what's in place. The next thing to look at then is, are there updates that need to be made in this plan? The Minnesota Power of Attorney, one that you very frequently will see, is called a statutory short form power of attorney. That document is updated and established by the Minnesota legislature. And why I'm bringing it up is because there have been two significant updates to it in 2014 and 2016. Because of those updates, I've had clients who have run into issues where they have an old power of attorney for someone and they give that to a financial institution, and that financial institution says, no, this doesn't have what it needs to have based on when the statutes were changed in 2014 and 2016. So do those documents need to be updated? If there are old documents, who are the agents that are named in those documents? Maybe it's not the right person to be doing the job now, but 10 years ago when the document was executed, they maybe were the right person. So based on who the actor should be now Maybe it used to be a brother and sister, but now it makes more sense to have a child be the one who's stepping in and making financial decisions on behalf of the family member who has the health event. Do we need to execute a new power of attorney? Do we need a new healthcare directive? And beyond that, if this person now has a health event that is going to require long-term care, what's their life expectancy? And do we now need to be concerned about what their estate plan is? Do they have a will? Do they have a trust? Do they have beneficiaries named on their assets? If they die tomorrow, where are their assets going to go? And is that still what they want? Do we need to make those updates? Beyond that, if we do identify that there are changes that need to happen in those documents, does that person have the capacity to update them? So capacity is the ability to understand and make changes with a legal document. If that person is unconscious and they're not going to be conscious for a while, they don't have capacity. They can't sign a new power of attorney. They can't sign a new healthcare directive. If that person has a dementia diagnosis, maybe they don't understand what's going on well enough anymore in order to sign a new document. And if that's the case, then we may either be stuck with what they've already had in place and we just have to figure out how to work around it, or maybe what needs to happen if they don't have anything, because it can happen that they didn't do their estate planning, there's no documents. And the default, if there are no documents appointing people who can step in and make financial or healthcare decisions, is that we have to petition a court. And then the court has to appoint someone to act on behalf of that person. So that court process, that would be either a guardianship or a conservatorship. A guardianship in Minnesota is someone who has control of the body. So they decide where the person subject to guardianship lives, where they receive medical care, what types of medical care they receive. So it's sort of like the healthcare directive, only it's court supervised. The conservator is the person that has access to the finances. So they get court letters, they give those letters to the bank, and then the bank gives them information about what the assets are. When we talk about all of these things, we're always hoping that there was already a power of attorney or a healthcare directive in place. Because if we have to petition a court, if we have to go through that formal process, it can be very time consuming and very expensive. And the other downside of the guardianship and the conservatorship is that you don't get to pick who the person is that gets to step in and make decisions for you. And I'll bring up Britney Spears again. She didn't want her father being the one who was going to act as her guardian, but she didn't have that choice because the court made that decision for her. So if you have a power of attorney or a healthcare directive in place already, you get to make that decision, or the family member has already made that decision. Once we know who the person is that can help that family member with their health event, the next thing to do would be to assemble the team. So who are the players that are going to be able to help make decisions with what do we do now? Where is this family member going to live? How are we going to pay for it? What are the good methods of doing that? And there are a number of different people that can be involved in that decision. I've already talked about the elder law attorney and given you a little bit of an idea of what an elder law attorney would do, but also you would want to work with your financial advisor. So if that family member has a financial advisor, the financial advisor is going to be able to show, here's the picture of assets that your family member has, here's the income, here's the expenses if they've been working on planning with them, and here's how we could generally use these assets to pay for care. Here's the ones that are good to use, here's the ones that are not so good. A social worker can also be someone who's really helpful in that process. So a social worker can help identify what would be an appropriate care facility or placement, and whether there are services in the community to fill gaps in care that might be missing. My law firm has a social worker on staff who helps in that process. because we find that it all lines up when we get the legal affairs in order, and then we also get the care needs met at the same time. The accountant can help figure out what assets are best from a tax standpoint and whether there are any elections that we can make for deductions or otherwise. And then a public benefits specialist can help apply for benefits and ensure that we're utilizing every resource that's available to pay for care. Beyond that, loved ones we've talked about, they can step in and act as substitute decision makers. They can be the boots on the ground to make sure that family member's being taken care of. And then the medical professionals and the care providers can help meet that other side. The next step would be to determine the care plan. And the goal is always to ensure that that family member is comfortable and safe and well taken care of. And care can be provided in a number of different ways. There are in-home care services that can be hired. So if that person doesn't have a really high level of care, they can have care providers come into their home for a set amount of hours per set times per week. The problem that we find with home care right now is sort of the same problem with staffing that we're encountering across the board. With home care, you've got a specific person who's generally assigned to come into your home and arrive at different times. That person's job might be to get you out of bed in the morning, help you get dressed, help you go to the bathroom, help you start to have breakfast. If that person doesn't show up for their shift, that's a problem. So there are good things and bad things about home care. You can be at home, you can be in an environment that you're comfortable with, but if you have inconsistent staffing, that can be a problem. There are assisted living facilities, and I'll kind of lump them together with continuing care retirement communities. These are different than nursing homes. So they are facilities that have apartment-like living situations where service packages can be added on. And this is generally what you're looking at when you don't have a really high level of care. Many memory care facilities are assisted living facilities. So there are staff who don't have the same high level of credentials that are required for a skilled nursing facility, but you're able to live in a more comfortable community than a nursing home. A continuing care retirement community is a community that's designed to allow you to age in place. So within the facility, it typically includes services all the way from independent living up to skilled nursing, with the goal being that you move in there and you don't have to leave. Continuing care retirement communities, you typically have a pretty big purchase amount that is similar to buying a condo or putting a down payment on a house. And then that's applied to the services over the course of your life. So the goal there again being that you can move into that community and you don't have to leave and you can age in place. The downside of a continuing care retirement community is that they're usually all private pay. So you have to have the resources to enable you to move into that type of community. And then beyond that, skilled nursing facilities, palliative care and hospice. Skilled nursing facility is a nursing home. They typically have an RN who's on staff 24 hours per day, and they're providing that high level of care to the residents that live there. Palliative care is care just designed to relieve your symptoms, to make you feel better. And that can be received in any one of these different living situations. And then hospice is for people who've been given 6 months or less to live. It's comfort care designed at not treating the underlying illness that the person has been diagnosed with. And hospice, there are hospice houses. In Minnesota, one of the ones that I always think of is NC Little, where if you have weeks to live, you can move in there. Your family can come in there with you and receive hospice care until you pass. So those are our options for care. So the step then would be to determine, okay, which is appropriate for my family member based on what I know their goals were or what they're telling me that they are, and based on what their care needs are, what they're going to need in order to be happy, healthy, and well. The next step then is to look at what the finances look like. What money is available to pay for care? And that I recommend meeting with the financial advisor and assembling a financial picture. Whenever I work with clients, I have them fill out a very long packet, and they wonder, why am I filling out this much information? And it's because when we're doing long-term care planning, we have to know what all is available to pay for care. What's the tax qualification of those assets? Are we looking at IRAs? Are we looking at annuities? Is there life insurance? Is there long-term care insurance? Is there real estate? Because all of that matters when we're trying to figure out how much they're going to have to pay for their care at a long-term care facility and how long that's going to last for. So the financial advisor can help assemble that picture. And then the next thing to look at would be, is cleanup of this may be necessary. Sometimes we come across people who have 15 different CDs at 20 different bank accounts, and it can be really difficult as the person under the power of attorney to step in and start to find where all those things are and manage all of those things. So maybe part of it is moving it to be housed. And then the last question would be, are there assets that now need to be sold or liquidated? If the family member's not able to live at home anymore, do we need to sell the house in order to get some of the liquidity or equity in that home to help pay for care? The last thing to look at then would be, how do we pay for care? And this is probably the shortest slide for the beefiest topic that I have. Because when you're paying for care, there are a lot of different options available. And all of those options depend on how much money you have, what your care needs are, and how you ended up needing long-term care. The first thing that typically comes up when paying for care is Medicare. Now, Medicare does not pay for long-term care, except under certain circumstances. Medicare will pay for long-term care if you go to the hospital and you have 3 overnights in the hospital, and then you're directly discharged to a long-term care facility, a skilled nursing facility. Under those circumstances, Medicare will pay for up to 100 days of care, and after that, they don't cover anymore. And they may pay for 100 days. They only cover that if you are meeting certain qualifications for what your care needs are. So their goal is to make you better, but if it gets to the point where you're not gonna get any better, then Medicare will stop paying. Medicare also has a home care benefit that not a lot of people are aware of or utilizing. Medicare will pay for in-home care, but Medicare's home care coverage is limited, where it will not cover home care if the only care needed is custodial care. And what custodial care is, because that was my first question, custodial care is assistance with your activities of daily living. So if all you need is help with feeding yourself, bathing, toileting, transferring, dressing, Medicare will not pay for your in-home care. After Medicare days are done, then you're usually looking at private payment for your care. And that's again where we look at that asset picture. What are the assets that are available to pay for care, and how long are these going to last for? When privately paying for care, one of the big things to look at is, are there any tax advantaged ways that we can use your resources to pay for long-term care? There is a medical expense deduction that applies to payments for long-term care services. So what that means is when you file your taxes, if someone has been in a long-term care facility, if their medical expenses exceed 7.5% of their adjusted gross income, then those expenses can be deducted on their tax return. So if you're in a long-term care facility, a skilled nursing facility, you can deduct that, presuming that amount is probably going to exceed 7.5% of your adjusted gross income. Average monthly cost of care at a skilled nursing facility in Minnesota is about $6,000 to $9,000 per month. So it's pretty easy to hit that 7.5%. Because of that medical expense deduction, when privately paying, if there are tax qualified assets, IRAs, annuities, things that when you start to make distributions from them, you recognize income taxes. Those are really good resources for paying for long-term care. Because while you're creating income taxes on one side of the ledger, you're creating a medical expense deduction on the other side of the ledger by paying for long-term care services. So you have the effect of netting that tax consequence and maximizing the resources that you have to pay for care. One thing to be aware of is that assisted living facilities rent is not a deductible expense unless the person who's in the assisted living facility is determined to be chronically ill by their doctor. When that happens, then the rent is deductible, but you, to take that full deduction, you have to keep that in mind. Other resources for paying for long-term care insurance. Long-term care insurance requires some pre-planning. And to be clear, I don't sell long-term care insurance. I just know how it works when it comes to paying for long-term care. Long-term care insurance policies cover care in different places. Many of them have an elimination period of 90 days, which means you have to wait for 90 days from making a claim before the policy is going to start to pay for your care. Yeah.
In purchasing long-term care insurance, what are the ballpark range of costs?
That would be a great question for someone on Joe's team rather than myself, because they're all different, and the underwriting on a long-term care insurance policy typically works similarly to life insurance. So everybody's a little bit different because they're going to evaluate what your health situation is and that type of thing. The long-term care insurance policy, though, will pay up to a certain amount per day towards your care. So for example, it can pay up to $250 per day. And then it will pay out for a specific measurement of time or a total balance. So the $250 per day policy could pay out for $250,000, or it could pay out for 3 years or for 5 years. And some policies are unlimited. The unlimited policies are policies that you typically see were purchased in the 80s or 90s when long-term care insurance first started coming out, before the actuaries who were underwriting the policies figured out how expensive long-term care is and how likely it is for people to go in and need long-term care services. So the policies you see now are more limited. When collecting a long-term care insurance policy, you want to look at making sure that the person qualifies for the policy. They typically have to require assistance with activities of daily living, or they have to have a cognitive impairment that requires substantial supervision. And you also want to make sure that the facility that they're in meets the requirements of the policy. Some of the policies require that that person be in a skilled nursing facility in order for payment, and they don't cover assisted living or home care. So it's good to know what the policy covers. Beyond that, the last two programs, veterans benefits and medical assistance, are government benefit programs that can help in paying for care. Veterans benefits, of course, are available to veterans, and some of the benefits are also available to spouses of veterans. The benefit that probably most of us are familiar with through the VA would be care at the Minnesota Veterans Home. Minnesota has 5 facilities in the state that are veterans homes. Those facilities provide skilled nursing. The one nearest to us, of course, is the facility in Minneapolis. And in order to be eligible to receive care at the veterans home, you have to demonstrate that you've had an honorable discharge and that you've had 181 days of active duty service, and that you're a resident of Minnesota. And if you qualify for that, and if your assets are below $3,000 for just a single person, then the VA will pay for your care at that home. If you are married, your spouse's assets are not deemed when looking at asset eligibility for paid care. So what I mean by that is that if the family member that you're working with has $3,000 or less and a spouse, and we move any excess assets into the spouse's name, so a family member going into the facility has $3,000 or less, spouse could have unlimited assets, their care will be covered by the VA, and they don't look at what the community spouse has in their name. So that's a really huge benefit for our veterans. The spouse can also receive care in the facility. So if you're married to someone who had service that meets those requirements, the spouse can go in if they have those long-term care needs.
Do they have to go into the care facility to get benefits?
Yes, for this particular type of benefit that I'm talking about, yes, it has to be a specific Minnesota VA home. And that's through the Minnesota program. There are federal benefit programs that allow for payments for facilities that are not just the VA facilities. So you led right into my next topic.
You are.
The federal VA provides a program called VA Improved Pension. And the pension can be combined with a benefit called aid in attendance, which when someone needs to be in a long-term care facility, or they need to be in a skilled nursing facility, or they need in-home care, then they can get a monthly benefit to pay towards that care. You have to have assets, your net worth has to be below $130,773, so there's an asset requirement for that program. But it has about $2,300 per month then that would be paid to the veteran or to the surviving spouse. So the spouse can't collect benefits unless the veteran is deceased in order to apply towards care. The other benefit though too, depending on your status in the VA health system and depending on whether you have service-connected disability, there are also community living centers through the VA that you can go to and receive care at too. And some of them are licensed, contracted nursing facilities apart from the VA homes. The last option, or the last ditch option, would be medical assistance. I always list medical assistance last because it has the most attractions. Medical assistance will pay for care in home, at an assisted living facility, at a skilled nursing facility, so long as your assets are limited. For a single person, you have to have $3,000 or less. If you have a spouse, that spouse can have a house, a car, prepaid funerals for both of you, personal property, and then $130,380 or less. Medical assistance pays for care in home and assisted living facilities, but that assisted living facility and the home care agency have the ability to decide whether they are going to take medical assistance. So the program through medical assistance that pays for home and community-based services is called the Elderly Waiver. And again, not all facilities take Elderly Waiver. So you have to be careful about if you're choosing a facility for someone and you know that they have limited resources, choosing a facility that's going to accept medical assistance if that's something that they will need. Facilities that take medical assistance, assisted living facilities, can also say, yes, we take Elderly Waiver, but you have to live here for 1 year or 2 years before we're going to start to accept medical assistance for payment. So when you're looking at choosing a facility, another thing to be careful about is if there's a private pay period requirement, ensuring that there are sufficient assets to pay through that period. Because if the person who moves into that assisted living runs out of money and they've not hit that private pay period and the facility's not going to take medical assistance, even if they can get approved for benefits, they're going to have to find somewhere else to live. And that's not something that you want to deal with. The other downside of medical assistance is that there is state recovery. So none of the veterans programs, if you receive services through the VA, regardless of whether it's state or federal, you don't have to pay that back. With medical assistance, your estate has to pay it back. So on your death, whatever is in your name is subject to a claim for the amount of benefits that were paid out by the state of Minnesota on your behalf. If you have a spouse, that claim is delayed until the death of your spouse, but still, before anything would pass on to the heirs, Minnesota gets paid first. So I know I'm hitting half an hour here. I guess we can take questions now if anyone has any questions. Yeah.
The 180 day for the veterans, is that are there exceptions to that then?
It's 181 days of active duty for the veterans home. For the federal programs, for aid and attendance, it's 90 days. And that 90 days has to coincide with a wartime period. And the wartime periods that we generally see right now that are recognized would be World War II, Korea, Vietnam, and then the Gulf War.
Does a trust protect your assets from anything? Them coming after them?
Yeah, so that's a complicated question. And the reason that that's complicated is because Minnesota has a statute that says that if you transfer assets into an irrevocable trust, so an irrevocable trust is a trust that you can't change. Generally, the trusts that we see for estate planning are revocable, because you want the ability to change your estate plan. The statute says if you put assets into an irrevocable trust and then apply for medical assistance benefits within the look-back period, which is 5 years, that trust is deemed revocable. The reason that that's a complicated question is because there was an appellate case recently that found that that statute is in conflict with federal law. That case hasn't been appealed to the Minnesota Supreme Court, so it's an appellate case. So arguably now, yes, you could use irrevocable trusts, but my question would be, do you want to be the test case and wait for 5 years to see how the Department of Human Services is going to take it? So the answer is yes and no.
But revocable trust, they can come after.
Revocable trust they can come after. And the way to think about it is an asset is available if you have control and access and the ability to use it. So a revocable trust is the same as you. You don't change anything by establishing a revocable trust. You put the assets, the same assets that you have right now, you retitle them into the name of the trust. And the trust says, while I'm alive, this is who's going to control the assets. Usually it would be you. If I'm incapacitated, this is who's going to control them, and this is how I want them to be used. And after I'm dead, here's where they're going to go. But you can reach in and you can take all the money out of that trust. So it's available to pay for care.
How about the question for Wisconsin? Same answer or?
I
Same
am not
question for
licensed
Wisconsin.
in Wisconsin, so I can't answer that question for you, but I believe that the answer is that in Wisconsin you can use irrevocable trusts. But I'm gonna give you the caveat that I'm not a Wisconsin attorney.
Some people travel from out of state.
Sure. But remember that just because it would be a Wisconsin irrevocable trust, if you applied for Minnesota medical assistance benefits, it's going to be subject to the laws of Minnesota.
Does the 5-year look-back period apply to gifting as well?
It does, yep. And the veterans programs that we've talked about, they also have look-back periods. So a look-back period, just so that everyone is clear, is the period of time before you apply for benefits that you have to report any gifts that happened. And depending on the programs, there are different penalties if gifts occurred during the look-back period. So for medical assistance benefits, it's a 5-year look-back period. So any gifts that occurred within the 60 months before you apply for medical assistance benefits have to be disclosed on the medical assistance application. And then what happens is that they apply a penalty divisor, which currently the penalty divisor is $8,781. So for every $8,781, that's 1 month in the long-term care facility that medical assistance isn't going to pay for your care. So if you gave away $87,000 during the look-back period, that would be divided by 8781, which would be 10 months. So for 10 months after application, you would have to privately pay for care. And the key to the penalty is that you have to be otherwise eligible for benefits for that penalty to be imposed. So that means if you're single, you have $3,000 or less. So if you have a 10-month penalty because you've given away $80,000 before you applied for medical assistance, you've got a problem because you don't have money to pay for your care if you're paying between $6,000 to $9,000 per month. So then you look at, can I get the money back? Can I ask the people that gifted the money to return that money to me? Generally, people don't hang on to that money for 5 years just in case you might go into a nursing home. Can you get payment from other resources? Are there family members that would help pay for care? Probably not, because again, not a lot of people have $6,000 to $9,000 per month just readily available. I wish that was not the case, but, and then beyond that, you can try to apply for what's called a hardship waiver. And a hardship waiver is going to the county that you apply for medical assistance through and saying, I need this care. I tried to get this money back. I will die if I don't receive this care. The nursing home or facility that I'm in is trying to evict me. Can you please make an exception? If that hardship waiver is granted, then what happens is that the county attorney then has the ability to take a cause of action against the people who received the gifts. So he or she can go after the gift recipients, which is also not a great solution either, because think of who you were giving money to in the 5 years before you had to go into the nursing home. You're probably not giving it to people that you don't like. So also not a great solution. But what all that goes to is it's very important to plan in advance in case something would happen, so you don't end up in those circumstances where you're scrambling to get medical assistance and apply for a hardship waiver, and you not only have problems, but now your family might have problems too. Yeah.
Does the law make any distinction between gifts to charities and gifts to individuals?
It's a great question. It does. There is, for charitable giving, if there is a pattern of giving, and I want to clarify that what I'm talking about right now pertains to medical assistance. If there's a pattern of giving, so you may be tithing or you give the same amount to the same charitable organizations every year, then that is disregarded. But if you take $5,000 and give it to your church and then apply for medical assistance the next day, that's probably not going to be looked on as favorably because it's not a pattern. There is not the same exception for gifts to family members or individuals. So any gift that's given to an individual is scrutinized, and you have to be able to show that it was payment for services or something that doesn't count as a gift for it not to be counted. Yeah.
You said in the long-term communities, there was a buy-in. If
Yeah,
you
the
die,
continuing
if you die
care
suddenly, is there,
communities.
you get some of that back? Is it worked in?
There is, so it depends on the community. All of them have different contracts for moving in, and then there are also all kinds of different buy-ins. And it's another thing where I know just enough to be dangerous. The ones that I have seen, generally, if there is an amount on that buy-in that's remaining, it is paid to your estate after the unit that you're residing in is taken by another person. So that's what I see most commonly. Sometimes the agreements will be written up where if you needed nursing services, long-term care services, that would reduce that amount. So it's you can kind of think of it in some of those facilities as prepaying for long-term care services. But then also purchasing the peace of mind that if that amount of money that you contributed to the continuing care retirement facility is exhausted, they're not going to evict you. Yeah.
I'll ask another one. In long-term care, is there usually a separation? When my dad went into memory care, he wasn't going to a nursing home, so they denied the payment because it wasn't a certified nursing home. And then you had to kind of do a workaround because he was cognitively impaired, and then they had another area that you could get the same payment per day, but they didn't seem to volunteer that information. So is that typical in long-term care?
Are you talking about long-term care insurance?
Yes, he had long-term care insurance. So
Yeah.
when he was moving into since it wasn't a nursing home, they said, well, we're denying your application.
Yeah.
But they didn't really offer this other area until we pressed it.
Sure.
So is that
Well,
typical?
And the thing to keep in mind with that is that the facility doesn't necessarily know what all the terms are in that long-term care insurance
This wasn't the
contract.
facility.
Oh, it was,
We were just
it
working
was
with
the long-term care insurance? Well, they
Mhm.
didn't want to pay.
But,
But-
well, I didn't say they didn't, but they
Yeah.
didn't really let us know that finally then, well, we'll deny this, but you can apply then for this other aspect, which we didn't even know was there.
Sure. Every long-term care insurance policy has its own separate contract, which sets out what the rules are for when the company will pay and what services they'll pay for. So when I'm working with clients, I'll usually review that contract to see what's going to be covered, and then look at the facility to see, is this going to match what the terms of the contract are? So it sounds like what that was is a contract issue. But long-term care insurance can sometimes be difficult to collect. I had a client that I worked with a long-term care insurance policy where she needed to be in an assisted living facility, but she didn't meet the activities of daily living that were required under the contract, which stinks because she's invested all of this money into this long-term care insurance policy, and then she didn't have the ability for it to pay out until I think she had a heart attack or something like that, and then at that point she needed help with her activities of daily living, and then, but you know, especially with dementia, if you're trying to get someone certified as cognitively impaired, what happens if they meet with the nurse hired by the long-term care insurance company to evaluate their care needs on a day when she's having a good day? She still needs the care, she's still cognitively impaired, but they didn't make that evaluation because it was a good day. So,
All right, how about a round of applause for Lauren? Thank you so much for coming. It's been very insightful. Yeah, I'm gonna make sure you hit this slide. If any of you want to talk about individual circumstances, you know, that's the name of the law firm, Mazer, Amundsen, Bozio.
yeah.
Getting good at these names. Yeah, you can certainly give her a call. Talk about, like I said, your individual situation. We're glad to talk about as well. Obviously, here at Secured Retirement, we don't give the legal advice. That's where Lauren comes in. So thank you all for coming. If you want to grab a cookie or pop, another sandwich on the way out, please do. I'm sure Lauren might be around for a couple minutes. I'm sure you have other things to do today, so probably have to run at some point here. And, I'm around to answer questions as well. So thank you again. Enjoy your day.
Thanks, everybody.